When we talk of IP revolution, certainly we think of technical innovations, we think of creativity, we think of new technologies, and we have been talking about AI since morning, and we have been generally talking about AI everywhere. But if we think of IP revolution at a deeper sense, it is not just the technology. It involves a lot of other things. It involves policy decisions, IP law, IP practices, enforcement strategies by the industry. So all of it put together brings a revolution. So when I think of current technologies, certainly AI is there, blockchain is there, quantum computing is there, and data itself. Like you take anything, it is all centered around data. And every industry wants to have data set, every country wants to have data set, every country wants to have control on data and have a sort of, make their network faster and faster to make it transit from places. So AI certainly will restrict ourselves to AI of now, and then we'll bring in some public-private partnership factor to it. Has caused a revolution, not only the sense of technology it is coming up to. It's, you think of healthcare, you think of agriculture, you think of weather forecasting, you think of tools to assist lawyers, to assist judiciary, genome analysis, telemedicines, personalized medicines, personalized fitness programs. You name anything and you see AI there. So not just with that factor, it has certainly nudged the policymakers, the IP practitioners, force them to think the traditional ways won't work. It is time that the practices change, the law changes, it makes space to accommodate and adapt the new technologies. So I am a life science person and have got the opportunity to work with some healthcare industries which work at the intersection of healthcare and AI. And apart from technology, the other question that often comes up is when they need data to train their tool, they go to hospitals, they go to patients, they go to clinics, they need data to train their tools. Who owns the data? That's a very critical question. And along with that comes in picture the privacy laws. Because at the end of it, you are actually dealing with human data. You take your wearables, your smartwatches, your fitness apps, they have so much of your data. So you have to take care of the privacy laws. At the same time, you have to take care of the ownership issues. And all of this has to be sorted out, not after the technology has been validated, not after you have been through the phases of development. It has to be discussed and documented at the beginning of your project, your research. So I'll now come to Aakansha. Aakansha, you are a litigator in IP field and certainly dealing with copyright and medical AI issues, media industry, entertainment industry. So how is this AI impacting some ownership issues in entertainment industry? There is so much of noise about AI in entertainment. Would like to have some thoughts from you.
Good evening, everyone. Okay, we are all pretty dead in the room. I understand that. We are sleepy. Can we please have some music? I'm not asking any one of you to dance, but you are allowed to. Please go ahead. Can you play the first slide? Click once more. part of the song called Hearts of Sleeves. I don't know how many of you know about it, but that's a song by Weeknd and Drake, two very famous artists, mainly based in the US. Now, why am I discussing this? The point of discussion here is that the song was not composed by Weeknd and Drake. It was composed by someone called a ghostwriter 977 using an AI tool. What has he done? He's come up with the lyrics by himself. He has trained an AI tool to mimic the voice of Drake and Weeknd and produced a song. Now, what is wrong with it? The lyrics are original, so he is the owner of the song. Unfortunately, Universal Music Group did not think so. And they ensured that they got the music down from every platform. But before they could do that, if I'm not wrong, the music hit about 9 million views. This is 23-24. Why did Universal do this? Universal's problem with this whole act was, yes, the lyrics are yours, but what is mine are the artists. I own all their work. So therefore, you have breached my contract with them, and in turn ensuring that they breach my contract. So it's a two-way breach where none of them are involved. That was the one biggest point. Second one was the artists haven't gotten paid. Despite the fact that it is their music or their voice that is being used, they have no royalty, they have no commission, there is no money they make of it, which is their right to livelihood, as we would call in India. The third thing was that when Ghostwriter 977 trained the AI tool, what did he do? Or what did she do? They copied Drake and Weeknd's voice, trained the tool, and then produced this music. So that initial copying was an infringement of their other music and their other voice and their personality rights. So copyright AI is not limited to just an author, to just an owner of the work. It is also about personality rights. In India, we are facing so many issues, and we've seen in the Delhi High Court, for example, on the daily, there are new cases being filed by a lot of these personalities, be it Jackie Shroff, be it Arijit Singh. They're all contesting their personality rights issues because AI is being trained to use their voice and make music without getting paid, an infringement of their personality because their voice is what sells. It is that likeness that they make money off. So therefore, we are in that situation today where we need a law which either recognizes or categorically calls out saying any product generated by use of AI is not a product that copyright can be granted on. And any product which has utilized a copyrighted work as a base will be infringement of copyright of whatever that base work was. That's where we are at with respect to music, personality rights, voice, likeness. And since we've been asked to keep it quick, I'm going to quickly jump into artistic work. Can we have the next slide, please? Yeah. Okay. No. The early one, yeah, this one. I don't know if the painting is visible, but does anyone recognize what this is? This is, yes, it is horse, but this is one of the most famous paintings of M.F. Hussain called Horses. Now, there are two versions of it, 1 and 2. Does anyone know which is AI generated, which is not? Yeah, but you're very close for it. Okay, so one of the ways you can figure this out is if you see in painting 1, on the right corner, you will see Hussein's signature, top right corner. Whereas the one which is 2, there is no such signature. It is 2 which is AI generated. But to a naked eye, you cannot figure out which one is AI generated, which is not. Am I infringing a copyright here? It's an arguable case. Because This I generated by giving a prompt to an AI platform. My prompt very specifically said, do not copy M.F. Hussein's horses. Despite that, I have generated a very similar image, which people who are not art connoisseurs cannot differentiate between. But the differences are there. One of them being the signature, one of them being the brush strokes, one of them, if you see the image on number 2, is much darker in color than image 1. The sketch, image 1 is more blurred lines, image 2 is much sharper. And that's where the problem lies. Today, we cannot figure out what is AI generated and what is not. And if this is the world we live in, without the laws that are required to regulate the situation, we are in a soup. Because we will have copyright infringements on the daily, and we have no recourse. Therefore, it is very important, and unfortunately in India, there is no law on this. There's no clarity on law on this. Because in India, we still talk about a person being an author of the work. Whether it is a literary work or a musical work, it has to be a person. Very recently, before the Delhi High Court, this question arose, this very specific question arose on whether a human being, along with an AI platform, be copyright owners of a work. This is a very famous case called the painting of Suryast, where a lawyer took a photograph and converted that into a painting utilizing the starry night as inspiration. Now, he wanted to register that. He did that in the US as well. US refused, the Copyright Office refused that twice. And in India, the first time he applied for a Copyright Office refused it because it was applied only in the name of the AI platform. The second time when he applied it with his own name, and the copyright was granted. Later, about a year later, the Copyright Office withdrew that approval. However, this was a question that Delhi High Court decided and said that copyright law requires a human intervention, and only then can the work be copyrightable. So therefore, it is the need of the hour to have a law either saying we can have AI and copyrighted works, which is the only way, to my mind, we can go. We cannot shut our eyes to the fact that AI exists. It exists in our daily lives now. It's not merely professional work that we're doing. So we, as lawyers, as people who can influence this, I think that's something we need to do. And as professionals in your own capacity, there is something that you would need to do in the future if you're a service provider, is to ensure that your contracts cater to all the AI that can be utilized in you providing the services. And as a receiver of the services, you have to ensure that the work that is being created for you, utilizing AI, all the licenses flow to you. Without the license to utilize that copyrighted work, you will not be able to use the work despite that work being work for hire. Thank you.
Thank you, Aakansha. You mentioned again a very critical point, which is the documentation. The contracts, the documents have to read very, very clear of all your negotiations. And I think on the authorship part, the law is quite similar to what we see in patents, because there again, the demand for inventorship is a natural person. And we have seen some good case laws in US and Europe where the courts have stated that, we will not believe AI as an inventor. And for an inventor to qualify, it has to be a human, a natural person. For the documentation part, my own experience of working as an IP attorney is that specifically for startups or any entity which is starting fresh, a lot of documents just go neglected. They are just taken as secondary things. For example, founders agreement. In a lot of cases I've seen, it does not very clearly identify if a founder leaves, who keeps what, and the leaving partner takes out what, with whom the IP stays, what percentage of certain brands or what number of brands or trade secrets the outgoing partner can take along. In instances where, for example, party A and party B come together and start an entity, where both of them come together with a separate set of IPs, what is going to happen with the background and foreground IP? I have literally seen these agreements which have basically no mention of IP, technology know-hows, trade secrets. So I think as practitioners, it's also our responsibility to keep reminding our clients about the relevance of documents. Another aspect that have come to my mind quite often is so there is a requirement in the Indian Patent Office to prove as a proof of right, how the applicant acquired the rights from the inventor. And a lot of times we submit the employment agreement. Unfortunately, the line there reads as, which to our good luck is not noticed a lot of time by Patent Office. So the employee says, I agrees to assign. So it's an agreement to assign, but not an assignment per se. I agree to assign whatever technology I create during my tenure with the company X and so for the remuneration I get and so. But this is an agreement to assign. This is not an assignment per se. So it can be challenged as an assignment document. So documentary aspect, I think, need to be taken care. So Avijit, let's come to, because we are talking about technologies and we are talking about IP revolution. And a lot of time we think, that one entity may not be good enough to do everything. And we want organizations to come together and function. How a public-private collaboration would expedite R&D, at the same time would bring up more IP in the market, and we may see a further IP revolution coming from IP industry partnerships. Your take on this?
Hello. Good evening, esteemed speakers and ladies and gentlemen present here. The intellectual property rights that creators and innovators are given over their intellectual works, including inventions, designs, literary works, and the trademarks, are known as intellectual property. By offering incentives for innovation, lowering risks, and simplifying the commercializations of research results, a strong intellectual property system is essential for advancing research and development and public-private partnerships. There is significant role of IPR in research and development, especially in reference to India. These patents in particular give innovators temporarily exclusivity under IPR. Businesses, academic institutions, research centers are encouraged to invest in expensive and risky research and development by this exclusivity. Thereafter, the research findings that are protected by the IPR from unapproved use and copying. This is the special crucial for Indian academic institutions and entrepreneurs who might not have the resource to complete without legal protection. Copyrights and patents aid in turning research into commercially viable. Indian organizations that aggressively license patent and innovations to industry such as CSIR, IITs and ISS. There are a lot of IPR in public-private partnerships makes it clear who owns ideas created in collaborations between the public and private parties. Private entities are more willing to collaborate with public institutions when assured of IPR protection. This is crucial in sectors like healthcare, pharmaceuticals, defense, technology, and energy. IPR makes it possible to transfer publicly supported research to private organizations through organized licensing. For instance, under license agreements, private companies may commercialize government-funded research. PPPs allows for the expansion of patented technologies for general public in use. In India, the public interest is protected by mandatory licensing and government use regulations. Strong IPR frameworks are essential for promoting public-private partnerships based innovations through programs like Make in India, Startup India, Atmanirbhar Bharat, and National IPR Policy 2016. There are some private-public partnerships in India, that is CSIR. CSIR holds thousands of patents in pharmaceuticals, chemicals, and industrial processes. These patents are licensed to private companies for commercialization. Most recently, the COVID-19 vaccine, it is a public-private partnerships involving the Indian Council of Medical Research and the Bharat Biotech. IPR ownerships and licensing terms were clearly defined between these partners. In addition with that, there is a Bayer held a patent on the cancer drug Nexaviter, priced very high in India. But now India granted its first compulsory license to Natco Pharma under the Patents Act 1970, allowed a private Indian firm to manufacture a cheaper version for public benefit. IIT Delhi, IIT Bombay, and IIT Madras actively collaborate with the startups and industries. Universities retain IPR over inventions created through publicly funded research. ISRO is also an example of private-public partnerships. There are few challenges still in this area. That is, balancing intellectual property rights protection with the public interest is a critical challenge in the pharmaceutical sector. Strong patent protection is essential to encourage innovation, research, investment in the development of new drugs, which involves high cost, long timeline, significant risk. Without adequate IPR protection, pharmaceutical companies may lack incentives to invest in research and development. At the same time, excessive or rigid enforcement of patent rights can restrict access to affordable medicines, particularly in a developing country like India. One of the biggest problems in India is that researchers and MSMEs still have a lack of awareness, understanding of intellectual property rights. A lot of innovators don't know enough about the business significance of intellectual property rights, as well as the delays, prices, and procedures involved in submitting patents. But because of these, valuable inventions frequently go unprotected or are revealed too soon, which results in ownership and competitive advantage being lost. Now, negotiating intellectual property rights ownership in public-private partnership agreements is often complex due to different objectives of the public and private partners. Public institutions typically aim to ensure widespread access, affordability, and public welfare, while private entities focus on commercial returns, exclusivity, and competitive advantage. These differing priorities lead to challenges in deciding ownership of jointly developed IPR, revenue sharing arrangements, licensing rights, and control over future use, modifications of the innovations. Issues such as the background of IPR, foreground IPR, rights to improvements, and cross-licensing further complicate the negotiations. Ambiguity and imbalances in IPR clauses can result in disputes, projects delays, and reduce the private sector participation. So therefore, clearly defined IPR frameworks, transparent contractual terms, and standard model guidelines are essential to ensure fairness, reduce transactional cost, and foster successful and sustainable PPP collaborations. So intellectual property rights play a pivotal role in strengthening the research and development and fostering the effective public-private partnerships in India. By incentivizing innovations, facilitating commercialization, and enabling collaboration between the public and private sectors, IPR contributes significantly to economic growth and technological advancement. In India, must continue the refining its IPR framework to balance innovation incentives with broader social needs. Thank you for.
Thank you, Avijit. So the point taken is, while joint ownership looks a very effective tool, but it comes with its own frictions. And IP strategy is of importance and really has to be decided before you actually go ahead with R&D and all the commercial factors come in. Because certainly the public entity would look at the public benefit and private entity would look at the commercial gains. Strangely so, when we talk about IP strategy, generally it is left, the thought is that it is the job of the IP lawyers only, whether you take it in-house or you outsource it to someone. In an ideal situation, IP strategy should actually involve all the stakeholders, starting from the R&D team, to the marketing team, to the business fellows, and then certainly the IP lawyers. Because R&D team would know what's in the pipeline, what has been the costing into it. The marketing team, the sales team would tell you which jurisdiction is of importance to us, which product has the customers in the market. So it is not a thing which need to be just left for the IP lawyers to decide, but all the stakeholders have to come and sit in for the discussion. And the IP strategy obviously is not a dormant document. This is another thing that I have seen with the industries is they think they have framed it once and they framed it forever. It's a very dynamic document. It has to keep evolving, considering certainly the market trend, the geopolitical situation, the consumer demands, and what your competitors are doing. So thank you, Avijit. So going to the next talk. So he's not there? He was here? Oh, so Abduraheem was supposed to join us on from Dubai, but there's been some technical glitches. So I think then we can have some more discussion, maybe just 5 minutes. Is that okay? So one quick thing that comes to my mind is that ChatGPT has given some good work to lawyers. Suddenly there are a lot of court cases. Suddenly even we patent lawyers have started talking about copyrights. So everyone's talking about copyright. Would you like to talk about something?
Like I was saying, we need to take a call and we need to take some actions on copyright and AI, which the Indian government supposedly has done. They've come out with a white paper. DPPIT has come out with a white paper on generative AI and how that can be controlled and how can AI platforms utilize that. Now, there are a number of concerns with that paper. My primary concerns are two. One, the paper has gone on to treat AI and Gen AI as the same. There is no differentiation. And two, the paper jumps to a solution without correcting the problem. Now, what does the paper propose? The paper proposes that we should have a pool of copyrighted works where the content creators will not have an opt-out position or an option. The content creators will be given so-called royalty, which will be pre-decided by a committee, and all AI platforms can utilize that copyrighted work to train their platforms. This is a one-time license that they'll have to take and one-time payment. Now, as I said, there are a lot of concerns with this paper, and I think about this time is by when the comments are closing on the paper. But the primary concern is that we have not figured out whether an AI-generated work is copyrightable or not, but we have jumped into the fact that we can give you copyrighted work to train your model. And that's my biggest concern with that paper. Let's see what comes out of that paper, because half the time we see papers are written, it doesn't see the light of day, there is no law that comes out on it. But let's hope that the comments will address these problems and we will have some amendments to the Copyright Act in the near future.
Are we going to wait for... Okay. So, Avijit, for the PPP mode of R&D, so generally, we have these clauses of dispute settlements. And what happens is when these agreements come to us, So obviously the public entity says, no, it will stay at the place of, where my residence is, my place. And the private entity doesn't feel very comfortable about it. So this is something, which generally makes things a little difficult for us. And a lot of time, it may be lack of awareness, where we suggest that, let's go, you should have the clause for arbitration before actually jumping into the court directly. I would still call it lack of awareness. Most of the entities doesn't agree to it. So what is your take when these issues come to your notice? How do you handle them?
First of all, I want to give a confession. I am not, my core field is not the intellectual property rights. Okay. But from the experience, I can say that private entities are always, is sole motto, or the major objective is to earn the profits or commercializations of the rights. But the public authority should not commercialize that things very openly. The public authority should take care about the public good. And what is like a COVID-19? It is an action research. That was the demand of the time, when the public authority, the government, has to depend on the private authorities who take the initiatives, who do the researches. But that research on very speedily done. And when it is done, it is applied. But now there are several complications are coming into the news, that the several healthcare professionals are saying that due to that vaccines, there are a lot of physical problems that has been created. So what is done? Because that was the needs of the time, that immediate actions has to be taken by the government as well as with the help of the private entities. If we had the time, enough time, then public authorities shall take more care about before it's launching to the public. So privatization, public authority should be very careful before allowing the private organizations for their apply their research into the society. That's all.
With respect to dispute resolution between public and private partnerships, one thing in my experience, no public authority ever says no to mediation. So that's always a good thing to add to your contract. Secondly, at least in India, a lot of these public authorities have their in-house mediation, dispute resolution mechanism available. For example, PWD, NHAI, their in-house mechanisms are pretty robust. So it's always good to have that clause in your contract and go on from there to arbitration. Even if you don't have arbitration, you next will be court. So have one ADR mechanism and insist on it, is what I would say.
Alternative dispute resolution is always good. It will reduce the burden to the courts, and the dispute can be resolved amicably without...
We have largely covered our points, except that our fellow speaker is facing some difficulties. Rajat, we should. So I think we'll conclude. There were some technical glitches. The virtual world didn't work this time, and that was quite similar to his topic. Yeah, if he joins later, he can have his talks, or we can just put the questions to him. Yeah. Any questions?
I think the question is, when do we get to go have coffee?
Yeah, right. Done? Okay, thank you.
Thank you so much, ma'am. Thank you so much, Avijit. Thank you so much, Aakansha, for enlightening us on such a beautiful topic. This dialogue reminds us that, the future is not that which we are waiting for. It is something which is shaping through decisions making today. We are making a decision trip. So thank you so much. Just I'll call on stage Rajat to present those mementos to the panelists. And ladies and gentlemen, please put our hands together. Thank you.